we are not bothered. All right. So we are not bothered about it. What I'm telling you, because law is such a tool whereby you can interfere on each and everything, right? So that is what I'm telling you. The consent is important in the contract. So when moving forward, I have not put so much of content in the slide. I just wanted so that you can know what we are discussing here, right? So if you can just, Akshay, is my screen moving? I switch to the next PPT. Is it moving?
Yes, it is moving.
All right, all right. So now coming to this importance of particular law of contract. So if I want to say from my side, even you all can understand there's a lot of things that is involved in this law of contract, and we our daily life from like the moment we get our birth to the till the end of a life, we are involved in, we can say, thousands and thousands of contracts and agreements. But point is how many you can enforce in the court of law, how many you cannot. So here lies the importance of why this particular law of contract is important. When you study in your law schools, some law schools give it as a subject contract law, some gives you law of contract 1, law of contract 2, and you need to study this particular law of contract. Right now, if you just talk about, I'm also teaching my first year students in the law, Bennett University, that how to study this law of contracts. So first thing I made very important for everyone, whenever you study any law, don't just go here and there. Even before attending this webinar, at least have this barrack which looks like it, right? I cannot say anything which will be overpowering it. I cannot do anything which is against it. Whatever I'll give you, it might be interpretation, it might be construction, it might be anything related to this Indian Contract Act only. Because you all know in law we follow here in India an adversarial system where the law is already there. We only interpret the law, we only apply the law. It is not that we evolve the law by ourselves. So even if I become the author of any book, I cannot do anything which this act is not saying. So if I'm saying contract will only be only those agreements which are enforceable, I cannot deviate from that because this is the law of the land. And we have to abide by the law of the land. And you may connect your constitutional or fundamental duties also that talks about that when you're talking about any law, which is the law of the land, you have to abide by it. So this is the gist which I'm giving you, telling you first the utility of anything. Because if you just talk about in present day times, whatever we do, we need to see that what is the incentive behind it. If you just remember your class 12th, you have studied mathematics, sine theta, cos theta, integration, and everything. When you are studying law, what you are doing with that? Is there anything utility that is left from that? So, for example, you want to become an architect, then there is a utility of studying that thing. So, never just follow law as a field where you are not so much motivated towards anything that, yes, you want to practice this, you want to do this, you want to be so and so. So, my point here is whenever you are in the field of law, also categorize your area that, yes, this is the thing that you want to specialize in because it is a never ending process that it has a lot of things. If you just talk about barracks, if you talk about sections, there are a lot of things that you cannot always remember. You need to get yourself updated. So here lies the importance of this particular law of contract and the utility. So this is a private law. First of all, you have to understand this is not a public law whereby if there is a breach, then the state is going to prosecute and all. It is the parties only. So if there is a breach, you agree to it. And if you are mediating on it, no issue. The state is not going to interfere on that. But for example, if there are two parties, so they enter into the contract because they have to formalize their relationship. It may be something informal, but it has to be formalized so that if so and so is not doing it, there might be further repercussions, and the other person is ready that if so breach of the contract happens, then there are certain remedies also, there are certain actions also. So next is that you also want to have legally binding agreement between the parties to respect their mutual obligation towards each other. So same example that I quoted you, where your parent says anything to you, just like word of mouth, and later on they are not doing it, it doesn't give you that authority that you can go in the court of law that there was an agreement between us. All agreements are never a contract that you have understood. Only certain agreements which fulfill the condition of this particular law, which I just showed you in the barrack. The sixth section 10 of this particular law talks about that what agreements will become contract. Now it is very important to understand that what is an agreement before that and what agreements will become contracts is the next question. So therefore, when you are entering into any contract, you are trying to specify the terms, and that's why I say it is a private law. It is not only that the state has decided, and if a state says these things are the offenses, you are not supposed to do that thing. So for the contract, you are free. You have the party autonomy. You can put down your terms and condition, and that will be binding between the parties. And that there lies the concept of privity of contract and consideration that I'll discuss with you in between. So we understand the importance of this particular law of contract to dictate the legal consequences, that if any party tries to break the agreement, breach the promises, or they are breaking the contract, then at least you have some remedy against them, because then there will be nothing that you can do after that, right? Person can say that yes, I will do that thing. For example, you are in the law schools, you are much aware about this culture of making friends, and you, if for example, if boy promises something to a girl and later on he wants to deviate from the promise, can you say that there was a contract between you and him? No, because every negotiation, every obligation doesn't come into the realm of the contract also. It is only those obligation, those legal obligation where you had an intention to enter into a contract, right? And apart from the contract law, there are a number of the other laws. It is not everything is governed by the contract law. There are family laws, there is a Transfer of Property Act, there's a Sale of Goods Act, there's a Partnership Act. So there lies the importance of each and every law, which have its like beauty of the law. If we talk about contract, it is talking about negotiations between the people, and it is talking about how these negotiations are important and up to what extent you can carry out these negotiation. And also you have an autonomy at what point you want to just breach and you want to stay apart, right? Now coming to the next and talking about this particular law of the contract. So when we say Indian Contract Act, when we are in law, we can't be saying anything, just a word of mouth. There has to be section, there has to be laws that has to support it. So that is why I was showing you, if you have not noticed, this is the Indian Contract Act. I think my background is blurred, so you might not notice it properly. So this is the Indian Contract Act 1872. And so now if I just say the point arises here, now we are in an independent India, why we are still following this age-old law of 1872. If you have came to the recent news, now you have the three new laws which will be effective from 1st July 2024, the new your procedural laws and the that are replacing your IPC, CRPC and CPC. Sorry, evidence, not CPC. So this law is of 1872. Anybody who is here who can give me an answer why this law is still effective? I'll be very glad to know that if you know the basic of this thing. Anyone? The host can also answer if they know it, that why this law of 1872 is still effective. There must be some basis behind that. Anyone? Just have a dialogue, then we can have a fruitful discussion. Otherwise, it will be just saying and getting nothing from it. Can anyone just try? You can be wrong, not an issue. As a teacher,
Because
yeah.
yeah,
And
I think because there is nothing innovative which can be brought, and there are enough number of precedents already which have covered the complete aspect of contract act.
all right, that's also a very good answer. So, are you a student of law or are you some professional dealing with the law of contracts? Staff, right?
Practicing law.
Okay, all right, great. So, from the if you just talk about the academic sense, and if I just want to give an answer, this law is valid because this was not against the basic tenets of the thing. If you are aware about Article 13 of the Constitution, that says pre-constitutional and post-constitutional laws, right? So many of the pre-constitutional laws were validated if they were not infringing with the rights and they are not against the fundamental rights. So when we talk about business law in India, I think the validity to this law was given because we say Grandam is the constitution. So it means if constitution came in 1950, then Indian Contract Act was supposed to come after that, but not, because we were also governed by certain laws, and similarly that happens with the IPC also. Now we have the new laws, but because this law was not against anything that was being interpreted, that is what being interpreted. So if it is not against the basic tenets of the rights, then we are following this law. And yes, because till the time this is the only act, if I say, is not having so much of amendments because of the problem in this particular law. So when you talk about any business, if anybody asks you as a student also, I think the basic of any business is not first the constitutional fundamental right. It is first that you have the Indian Contract Act itself that governed the relations between the parties from 1872 itself, right? Then after that, you got the constitution and you gave us your fundamental right. But the basic law that governs the business laws is the Indian Contract Act. Be it company law, be it anything, but the definition of the contract doesn't change. It might be that the special laws are dwelling more into it, but the basic thing of what is a contract is the same, right? So when you see this alignment of the sections under the particular law, which talks about, there are total 266 sections if we talk about from the Indian Contract Act. But this act is beautifully divided into 4 parts majorly. So when you see from 1 to 76, you will see that all the things which are there from section 1 to, I think it is 75. So it is, there is an error in the slide. So if you see, that only talks about the general principles of the contract, right? Then after that, you will see few of the sections till 123 are being repealed. Now, why they are being repealed? Because it is now in a separate act itself called as Sales of Goods Act, which talks about the selling, buying of movable properties, right? For immovables, you again have Transfer of the Property Act. And when you again see the next step of this Indian Contract Act, then that is talking about specific contracts like indemnity, guarantee, agency, bailment, pledge. All these things are being discussed under this part of the constitution, this part of the your Indian Contract Act. So what I am telling you is to understand what agreement will be a contract. You can't just read section 210, or you can't to section 10 or to subsection section H, because to understand it, you need to go from 1 to 75 altogether. Then only you can say that yes, you have understood that what agreement is a contract, right? Because it's very easy to say an agreement enforceable by law is a contract. But if you dissect this particular statement, what is an agreement? It revolves on so many sections under this particular act to know what is an agreement. Then if we say enforceability, enforceability is again a deep, again a broader meaning to know what is enforceable. Because at the very first instance, your contract may be enforceable, but just presume after some time, there's an act of God or it becomes an inevitable accident whereby your contract ceases to be enforceable. So you will not say that your contract was void. It ceases to be enforceable. And if you just see the last definition in the definition clause, that talks about it. And you can relate it to section 56 of the Indian Contract Act that talks about frustration of the contract. So this is how beautifully this law is designed and connecting to the things. Although when I found this law, I do think that there are certain repetitions in the law. The legislatures could have drafted at a one place certain things, but they put each and everything in different sections, and that becomes like for us to remember each and every section together. For example, when you talk about competency, they could have discussed all the things under section 10 only, but for that they have moved to section 11 and 12. But the problem is that is not wrong. So we are not changing it, we are not amending it, right? But someday legislature might think and amend this law also. Nobody knows what is being done. So the name of the law can also be changed, seeing the present scenario. Because when you see the new laws also, there is a lot of things that got changed. But still some people are in favor, some people are against. Being an academician, we can be critical about it. We can't say this is wrong or this is right. We can just be critical that as per me, this is the thing, right? Then you see the other sections which are there that talks about the partnership, and still these are not in this particular law. They moved to the other particular law called as Partnership Act. Or you can say, then you have other laws also like LLP, then the extension of that company law, now the competition law and everything. So now the business law has reached to the heights where it is not easy to understand from just contract. But the base is your contract law, because if two people are negotiating at the world level also, then how that negotiations are valid, you need to understand that when it will be a contract, when it will be binding on them, right? So for the students here, I have just put it from the your first page of your BEREC, if you just talk about. So in this particular law, if you notice, this law is an old law that I already told you. This is from 1872. Can anyone here in the students tell me what does this Act 9 of 1872 means? Why it is written Act 9 of 1872? There must be some meaning behind it. We just flip the pages and we just go, what is the contract? We all understand an agreement enforceable by law is a contract. My whole 1 hour talk will be revolving around this particular statement that an agreement enforceable by law is a contract. But what is the meaning of saying that Act 9 of 1872? The first year students, second year students, final year student, anyone? No? All right.
Serial number?
Yeah.
It's the 9th act that has been enacted in that year.
Wonderful, wonderful. So it is being talking about that this is the 9th Act of 1872. So the laws that you get in a black letter law, and if you have studied the jurisprudence, each and every word, each comma, full stop, semicolon has a meaning there. And you can't just deviate from that meaning. You need to interpret, right? Some of you must have studied the subject of interpretation of statutes, whereby you understood that how we interpret the law. Sometimes you apply the literal rule, sometimes you apply the golden rule, and sometimes we are forced to apply the mischief rule to protect that the value of the law is not being diluted, or the intention with which the legislatures have drafted this law is not diluted. So it is very common to the people who have studied, but as there are the people who are very new to it, I will just tell them that there are the two dates that matter, right? One on which the act came into force and one on which the act will be effective. So if you talk about Indian Contract Act, if you just see the things that I have highlighted, it's the 25th April 1872, and then you have 1st day of September 1872. So these two dates are very important. One is that when this act was enacted, that is 25th April, and the other is 1st September 1872, when this particular act got enforced, right? So we call this act as the Indian Contract Act, and this is the law of the land by which we follow how the negotiations between the people are so connected that they cannot deviate from that if they wanted to have this intention that they want to enter into legal relation. Not just domestic relation, another thing, because your family affairs are, there's a family law behind that. You can't say that every negotiation, if I'm talking here and you are talking to me, I say this is not the contract altogether, right? But once you are done downloading the Zoom app, then you might have entered into a contract, because there were certain things by which you have this put up the things, and you just finished and you have set up on the app. So there are a lot of things on that. How many times we just forget to take the receipts when we buy anything, right? Because when we are so much, if you are buying this from a store near your shop, how many of you just take the receipts from the street vendors that you are selling me this vegetable or something? Nobody takes, because they don't have that system also. But yes, if you are taking 1 kg of apple from anyone and you are giving 200 rupees, and if you're coming to home and finding it out that yes, no, these apples are rotten or something, can you go to that particular vendor and say that you please return it and I want my money back? Is there was any contract that happened between you and the particular vendor who was selling the apple? Say yes or no. Was there any contract? Were we having any legal relationship when we buy anything? All right. So my point, that contracts are not always written contracts, right? The law says it can be oral also, it can be written also. But the point is, when we are focusing more on the written, it means we don't want anyone to deviate from it. Oral, there is a possibility you may not have evidence, you may lack evidences, and because of that, you might not be able to enforce your promise. That's why we always pressurize that if you want to do this, I may make yourself to write on the stamp paper, because that's a legal document. And if you are just saying it by words of mouth, then proving that becomes little difficult than the written words, right? Okay, so this is just a brief of what this law is, how what is the utility of this law, how beautifully this law is designed, and why it is being still following from being so much of old or 1872, right? So after this, I just made for you a few things. Everybody knows here that an agreement enforceable by law is a contract. Now, what are the agreements which you will take into consideration to call that such and such agreement is a contract? You all must have gone through a case which is very landmark in this contract, Kali versus Carbolic Smoke Ball Company, the Lalman Shukla versus Goridar, the Balfour versus Balfour, Fisher versus Bell. So there were a number of cases which talk about these concepts. Because if you see this particular law, it's the half of the page that will tell you the definition that this is this, this is this. But from 1872, there are a number of case laws which have which we came across and understood that yes, agreement, though it is a simple line, but there are meaning behind it. Every agreement may not be a valid also. It may be void agreement also, right? So if minor is going a person who is below the age of 18 years, right? Mine is one straight question to the people who are here in the 5th year of the law. Why we took 18 as the age of majority under the Indian Contract Act? why we took 18 is the age of majority under an Indian contract. Can anybody just tell me? Is this law telling us that 18 is the age? Please make an attempt. No one? I expect an answer. It may be any other person also who knows it. Because we all talk about that. Yes, 18 is the age of majority, but there might be some rationale behind it. Why we are taking 18 and why we are taking 18 for both male and female here. Can anyone just tell me? Because when you talk about juvenile, the age is different. When you talk about marriage, the age is different. When you talk about voting, the age there are certain laws that say that this is the age. In contract, it is just said that the parties has to be major. How we understood that major means 18? Anyone? So if you just read the section 11 of this particular act, this is referring to Indian Majority Act. So 18 is not given under this act. When this act is read with Indian Majority Act, that says that major is a person who is above the age of 18. So this is how you connect the law. That is why I'm saying Contract Act cannot survive in isolation. It has to be read with the other laws also to understand the true meaning behind this particular law, right? So in a contract, a series of things happens. You all know, if I'm going to any shop or I'm going to purchase anything, first of all, either this person can make an offer to me. So before the time when we were not having this supermarts, this hypermarts, this different things where we go and pick the things and put it in our basket, right? What happens is we go to the shop, we ask, I want this, right? And they either accept that yes, I will give you, or they say I'll not give you. But now what is happening when you are going to the supermarkets, what we are doing, you are just taking a trolley, putting the thing in your cart. And if you just compare it to the online platform, you are just opening the Flipkart app, searching the things, putting it in the cart. So at the stage when you are putting it in the cart, it is not that you are making an invitation. When they are displaying the items, that is an invitation. When you're putting the things in the cart, it is not that you are accepting their offer. It is that you are now making an offer and they can very well accept or reject your offer. So if at the point you are going to the desk, you are going to the cashier counter, the person who is making the bill, and some of you might have came across these situations. Sometimes you select the product, but the person who is billing says that no, this cannot be billed, and he rejects to give you. How many of that time understood this thing, or it came into mind that no, he has not accepted our offer? Nobody. Because it's the daily part. We think that this is the daily activity. When you study law, then you analyze, no, this is not just daily activity. There is a law that is involved in it, right? It is not just a daily activity. But for a lay person who has no connection with the law, he will just think, हाँ ये ऐसा होता है, हम दुकान में जाते हैं, सामान लेते हैं, हमसे नहीं देते हैं. But when we study law, then we interpret, no, this is not that he has rejected my offer. It is not that he has not given me, he has rejected my offer straight away. So there is no binding agreement between him and me because there are no reciprocal promises, right? So my point here is that before offer also, there is one stage called as invitation to offer, right? So we need to understand that actually it is an invitation to offer or it is an offer, right? So after offer, that it comes an acceptance. When acceptance is there, then the word offer is, like, you can say the offer become a promise, right? It becomes a promise. So when your friend says to you something that can you give me this thing, what he's doing, he's just asking you, it's an offer. And when you're accepting, okay, I'll give you, now that offer has become a promise that you will give him this thing and he will give you money because of that. So this is the thing, that there are offer, then the next stage is the acceptance. And when accepted, then the offer becomes a promise, proposal becomes a promise, accepted proposal is a promise. Other side acceptance is a promise. These two are reciprocal promises. And offer is an accept of that particular proposal as a promise is a consideration for your acceptance, and your acceptance is a consideration for your offer. So there are two promises which are forming the consideration for each other. And then we say these are reciprocal promises, and you came to an agreement. So this is the philosophy that you need to understand behind what is an agreement, right? Because we do have this time constraint. We are not going deep into the law, which section, which and all. I'm just giving you an overview. And how next we'll see how this is being done in the practical sense when you draft any contract between the parties, right? So next, what you after making an agreement, you just keep a check. Is this agreement enforceable by law? So there might be agreement between the two people. I'll give you 10,000 rupees and you just go and murder somebody. That is also an agreement. But if the other person has took the money and just went away, can you go to the court of law and say, no, this person has took the money, I want my money back? No, the court will not enforce it. It will just say it is illegal. This is not enforceable by law. Enforceable by law means the court will take your matter into consideration, because this is legal. This is applicable as per the law. Second thing also, you must have came across many situations where people give the money to the mediator and think that they will get them the employment in the public services. So if you're not getting the employment, and later on, can you say that I have given so much or so money, and this person is not giving me back my money? Because if you say that is bribery, that is corruption, that is prohibited. Law will not take into account what you are doing. It might be an agreement between you people. You agreed on it. But whether it has passed that check of enforceability or not, and that is why we say then agreements which have passed this check of enforceability becomes a contract. So you can draft an agreement, like you have an agreement to sell, and then your executed agreement became sale when the parties are actually paying, getting is registered, and the property is transferred. That is called sale. That is not agreement to sell, right? So these are the things which are inside this law, which helps you to identify. So for example, if you are a student of law, you are going to internships, then the people might give you, your boss might give you an piece of paper and say, please read this agreement. Is there any problem or not? These things you need to identify. Are they fulfilling these tests? Are they like there is a proper offer? Is there a proper proposal? Is there an acceptance proper? Is there reciprocal promises? Are the proper consideration, right? So in this way, you reach to an agreement, then you keep a check that whether this agreement is enforceable by law or not. And once it is enforceable, it becomes a contract. And once it is a contract, then if party breaches, then there will be some remedies. There will be some course of action that the parties have mutually agreed upon. Because it might be in the present time, the Mediation Act 2023 is also passed. You know that it is not always that you go to the court of law. You might also have a clause in your contract whereby you can put that if any dispute will be there, we'll solve by mediation, we'll solve by arbitration or any other method. So out of court settlement and other methods are also there. The problem is, what I'm saying is this enforceability. And that is why we are talking that there has to be intention between the parties, whereby they are intending that if such and such party will breach, will sue in the court of law, right? So one of the important thing that is important in the contract is this principle of consensus ad idem, right? Consensus ad idem means that the parties' meeting of mind has to be there. So if I am saying that I'm ready to sell my land and you say I'm ready to buy your land, but the point is I have 4 lands at 4 states in India. Which land I am willing to sell, or which land you are willing to buy, we are not having consensus on it. We are uncertain. And if it is uncertain, your agreement will be void as per section 29, because you are not sure. But if I say I am ready to sell my land at, for example, you can say in the state of Uttar Pradesh, then if you say, okay, I'm ready to buy your land, it means that we are having consensus ad idem as to which particular part of my land in the India I am ready to sell. So consensus ad idem means whatever the things that are in my mind, you are understanding this thing in the same way, in the same sense. Even if your sense is different, then for example, buying of the, I'm ready to sell my property. You are also ready to buy my property. But my sense is the state of Uttar Pradesh, you are thinking state of Madhya Pradesh. So we are not agreeing on the same thing in the same sense, right? So this makes that we are not agreeing, and hence your contract will be voidable. Because when your consent is not free, when you're not agreeing on the same thing in the same sense, because of consent, it may be voidable. Because of uncertainty, it will be void, right? So this is how you need to decide. And in contract, if we talk about, then from section 13 to section 30, you have to be very thorough to understand what is void, what is voidable, and what is valid, right? Sometimes it might be voidable, sometimes it might be valid, sometimes it may be void. So void as such is never a contract. Void as such is always an agreement, because if it is void, it has never been a contract. But if it is a contract and it ceases to be enforceable, then it becomes void as per section 56, right? Now, coming to the next principle, which revolved around this drafting, because I'll come to the drafting part afterwards, because when you know what things you need to look at in the drafting, it is not just this pro forma we have, because then you can just Google it out and you get so many of the forms, how the sale deeds is there, everything. Now it's just a click of mouse away, right? You can just Google it. And you have so many AIs now that can draft you for you also. But the point is human interference, our cognitive faculties are required to interpret actually what is right or wrong. Whenever anybody tells me that this AI is good, if you say ChatGPT, if you say Bard, which has now become Gemini and others, I simply Google myself. I simply put my name. Who is Dr. Preeti Singh at Bennett University? Is this AI able to fetch my information correctly? Then it fetched some AIs were able to fetch my information correctly, some were not. And that's where I understood that how much we can rely on these particular AIs. So nowadays you also have a debate over this AI, human interference and all. So my point is you can just download a sale deed. You can just download a format of the contract. You can put in your name. But the point is you need to understand what is written in this contract. What is the meaning of these words? So humans has to be there to invigilate or see that what is being happening, what is being investigated. So this is very important to understand, right? Just a second, I'll just have a glass. All right. So in contract, two things are again very important. One is, for example, I and Akshay, suppose if I take the example of the audience only, are entering into certain type of contract. And if I just remember the other name, Vaishali or Vaibhavi was there as a host, right? So for example, I agree with Akshay that Akshay, you just give me 10,000 rupees, and because of that, I'll just maintain. I'll give like contract notes to Vaibhavi. Right? This is a transaction that is being there. There are two promises. He's promising to give me rupees. I'm promising to give notes to the Vaibhavi. But in this particular contract, who are the parties to the contract? I and Akshay. But who is then a stranger? A stranger is Vaibhavi, though she may be the beneficiary. The privity of contract says the negotiating parties can only sue each other for the breach of the contract. One very good example that I can give you, some of you must be having your insurance, right? Life insurance. And if you are studying law, you are a student of law, who is paying the premium? Your father. Your father, right? But can your father in your lifetime just go and enforce that contract? Please give me the money of the life insurance. No. It is a contract between you and the insurance company, though the premium is given by your father. Premium means the किश्त जो हम देते हैं हर महीने या quarterly, half yearly, yearly of our insurance. So that is why that consideration, if you read the definition under 2D, when at the desire of the promisor, the promisee or any other person has done, abstained from doing, is doing, or will do, means past, present, future. So your father may put a consideration, your father is giving your fees, but actually who is in a student? You and the university has an agreement. Wherever you sign, it might be under the guardianship and all. So what I'm telling you that the parties who is a stranger to the contract might be beneficiary, might be a party who is putting the consideration. But when it talks about the contract, it is only a negotiation between the parties, and the privity of contract allows that parties can only sue each other, not the outside. In India, this is the thing. Outside, it might be different, right? So we have privity of contract. The contract is private, not a consideration. So privity of contract is not there. Consideration anybody can give. So if I and Akshay are having certain contract here, consideration can be given by any of the audience, right? Right? But audience cannot come then enforce. It is only I and Akshay can enforce the contract against each other. Means we can only sue each other in the court of law that so and so I want from the other person, right? So this is also in the law. Now we are coming practical. What is the essential elements of any contract to be valid? So first the thing I told you that there has to be intention in between the parties to create legal relation. If you're not having that intention, that example of home things, we agree to each other, friends agree to each other, we say we'll be best friends for life, then we depart away. What happens? Can we sue our friend in the court of law that he or she promised that we'll be best friend for life? No, because there it was just a type of obligation or something where we do not wanted to have legal relation. So contract law is important to understand legal relation, that what relations actually will be legal and what will not be legal. And for the trifling matters, you always know law don't take into account. Otherwise, the courts will be, as they are already burdened, they'll be overburdened with that. So intention to have legal relation is important, right? Again, that we have said consensus edidum. You have to agree your meeting of mind should be in the same thing, in the same sense. If I'm showing you this, you have to see this only. If you're seeing this side, this is not that. We are not consenting. We're consenting to this white part only, not this brown part. right? So this is what the importance of meeting of mind in the same thing in the same sense. Then you talk about competency of the parties. Yes, for any contract, the parties has to be major. If you are entering a contract with the minor, then the minor can flew away and he'll say, I will not perform this contract, and you can't do anything because they are straight away protected by the law that having a contract with the minor and any agreement with the minor is void ab initio. Even though you have moved to certain extent. Like most of you must have gone through the case of this Mori Bibi versus Dharmodash Ghosh, right? So I have just put sections here also for your information. If it is required, I can share the PPT at the end also. Now, free consent of the parties. One is whereby I'm saying I'll sell my land to Akshay and Akshay is paying me the price. Okay. Second is the host of this particular webinar is putting me on gunpoint and saying that you please sign this agreement and sell the land to Akshay. Here also sale is happening, right? You must have seen some movies, people put the gun behind the person and say him to sign or anything. So out of pressure. So if you see, that is called coercion, right? When you are making anybody to enter into the contract, for example, till the duration I'm being coerced, I may sign. But the moment I get this opportunity, I went to the court, no, I have not done this contract. It was under that coercion. So the court will always take into consideration that the consent of the party was not free, and hence it is on my option. Now, if I want to, okay, I have sold the land, I got the money, okay. Second is whereby I say, no, please give me back my land, right? So it is enforceable, it is voidable. We say that the party has an option either or. It is on me either to move forward or to get back. And similarly, it happens in the cases of undue influence, it happens in the cases of fraud, misrepresentation. So as per section 19 and 19 of the Indian Contract Act, this says that the contracts will be voidable if you are putting an element of coercion, undue influence, fraud, misrepresentation. There are certain things with respect to mistake also. For example, I just say that I have given somebody certain money and that person agreed that he'll kill somebody. This is a murder. This is that I'm conspiring with him. I'm giving the money. Can you say that I was not aware that IPC has murder as an offense? So any person who is a citizen of this country or living in this country cannot take the excuse that I was ignorant of the law. It is presumed that wherever you are, ignorance of law will never be an excuse, right? Ignorance of law will never be an excuse, even if you are unaware of the law. So even a lay person cannot have such thing, because the person who are murderous might say, I was not knowing that killing somebody is a crime, so now I have done no offense. No. Anything which is contrary to law, which is in ignorance of law, will always be an offense. You cannot take the defense, I was ignorant. Similarly happens in the case of contract. Then in the contract, you also have an element that for whatever thing you are contracting, it has to be lawful. For unlawful things, for illegal things, for something immoral, against public policy, you cannot have an agreement, right? So it has to be legal, it has to be lawful, the object has to be lawful. For example, I say I'll pay you 10,000 rupees. You do the household work of my home, and also I will give you certain tasks whereby the things are illegal. So because now this doctrine of severability will not work. So if somebody is giving you a deed whereby you have to see in the agreement that 10,000 was being paid for two tasks, one was legal, one was illegal. So as per section 24 of your Indian contract, the whole agreement will be void if you cannot separate the consideration for legal and illegal objects, right? Next, that is very important, and that is the last point of the section 10, that whatever agreements you have, it should not be void expressly. For example, if you are saying that, okay, let's have an agreement and by which I'll pay you certain money, but the point is that you will not marry at all in your life. So the point is you cannot restrain anybody from marriage. It is expressly given in the law. You cannot restrain anybody from like trade, occupation, profession. You cannot restrain anybody from legal proceedings. If you are making agreement of such a nature, then these are expressly declared as void, right? So this is the gist that I have just given you an overview about the Indian Contract Act, because I think that was only possible during this time. Now, when we talk about, just can I give it a clarification? Anything that you want to have a question or something in between, or I can move forward? Because the time is also, and I have a meeting at the next time. Anyone, any doubt in between? Can you just ask me so that I can connect in the same way?
Hello, good evening.
Yogesh,
Good evening, everybody.
good.
So the question is related to the brochures which are being floated by the builders. I'm talking about the projects which are covered under RERA. So how does
Okay.
the brochure come into the ambit of contracts?
Brochure
There are
is
the
just an, if the brochure is there, that is just an invitation to offer, if I say, right? Because you also have certain advertising guidelines. Just giving a brochure to anybody, for example, if you're talking about such thing, I may talk about it a very simple point whereby these students will also understand. We do have a university brochure, right? Right? So university brochure, student also believe if university brochure says 100% placement and student believes and enter into that university, and if he or she does not get the placement, he or she cannot sue, because that is just an advertising criteria, and that happened in one of the case of Khalil versus Carbolic. So I'll categorize them in the sense of invitation to offer, whereby when you are flipping through the pages, you are seeing the things, and you say that I want to buy or purchase this property, right? Then you are going to them to purchase a particular flat. That is called an offer from your side, and if they allot in your name, it means it is accepted. Now it is a binding agreement between you and them, right?
yeah, because I've just taken only 1 minute because high courts have interpreted even the brochures as a extension or a precursor to the agreement to sell, because that becomes a gray area. And nowadays they are writing some very small footnotes that this is subject to changes and everything. But high courts have
Right. Right.
taken
So, for
they have
example, mutual
limited
funds
in the
also. If you see mutual funds, the line that they just read it in a flow that they're subject to the market risk and all, right? So one thing that they are declaring it also, but they try to hide it also. So we have two principles also: caveat venditor and caveat emptor. People always talk about that the buyer has to be aware. The second is caveat venditor, that the seller also has to be aware. So my point is that both the parties to the contract have equal responsibility to disclose the material facts. So if we have the opportunity whereby we can see the material fact, for example, in the brochure, for example, for the sale of you are talking about flats and the property, if they are advertising, we also have an opportunity. We can go to the place, we can inquire. Why solely dependent on that particular thing? Somebody is doing something.
only one quickie,
Yeah.
like in banking system or in any other systems wherein all the contracts are pre-drafted. So
So can
how
you be
about
a little loud? Can you be a little loud?
hello? Yeah, am I
Yeah.
audible now, ma'am?
Yeah, you are audible.
Yeah,
Can just switch on
because
your camera, as it will be good to interact.
yeah, my camera is off, ma'am. Ma'am, what about the contracts which are already predetermined or predefined or pre-printed, like banking contracts in the case
Right.
of because these appear to be very unilateral.
Unilateral. Yes, they are
I as a
surely
customer,
unilateral.
so how we can tackle such issues in contract?
Sir, when we talk about unilateral contracts, these contracts are valid. There is no doubt. But the point is, in unilateral, the other party only has two options, either to accept or reject, right? So, for example, if at today I want to do an FD, that is the fixed deposit, which the HDFC bank. So, whatever is the rate of interest they are displaying, either I have to agree or I have to do not agree. Means I do not have an other party do not have an option to negotiate. So we only have two options, yes or no. And it also happens for these online softwares and other things. Most of the time, when we are talking about some written contracts, they are mainly unilateral. For example, I can just say for the railway tickets also. If they are displaying, we can't change anything. We either have to select from this to this station, whatever they have displayed. It's all terms and conditions from their side. We cannot put our terms and conditions. And that is the gray area for the unilateral contracts also. But again, we have an opportunity to either say yes or no. And that becomes, if we say yes, it means we agree to all these conditions, even if we internally feel that some of the conditions are not feasible to us. But that one click means you agree to all the terms and conditions. Can I proceed? Because I think only little time is left, right? So for the drafting part, I have just put certain areas that because this is not actually today we are looking for the drafting. So I just pinpointed certain areas which we should be vigilant enough to see that actually this agreement contains these things or not. So for example, if you're going on the internships, you are going to just review any document and see that whether this agreement is a proper contract or not. What the things that you need to look upon. It may be all of them, it may be some of them, it may not be that everything which I have just put it here is there. So there is no one straight jacket formula that yes, these things will be there, it is a valid contract. You need to look upon. So there has to be some step-by-step inclusion of certain terms, condition, clauses, and whereby you are expressing your needs and your wants, what you want between the parties in the particular contract. So first thing, we have to be very clear who all are the parties to the contract, who all are parties to this particular agreement. So we have to clearly identify what is the name of the party, who are actually involved in this contract. So for example, if somebody is under the guardianship or somebody is a minor, for example, the insurance contracts, minors also have the insurance contract. But wo guardianship mein hai. Guardians is there to as a guardian till the person is attained the age of 18. So we have to actually identify who is the party. So this is the one thing that you have looked into at the time of the drafting or when you are reviewing any document and saying that this agreement is a contract or not. Second is you have to be very clear about the background. For example, if I write, Dr. Preeti Singh, I should be writing either I'm son or daughter of somebody or assistant professor at some place. Means there should be some brief introduction. So when you are selling a certain property, then you all can just review. Students, you must have the property papers. You can just see that I so and so, son or daughter of so and so, residing at so and so place. So this is giving the brief background of the parties while at the time of the drafting, and that's how the agreements are being drafted. But what happens when we are practicing, we already have a drafted format and we just change the name of the parties. If it is for the sale of the property, we already have it, we'll just change it. And there are a lot of the advocates who are sitting outside the court and doing this work of drafting because now it becomes a practice. They have done so much of the things, they now it's all being drafted with them, they just need to change the names. They had just put that thing. Example, university, if you are in university, you might be asked for anti-ragging affidavit and all. This is all being drafted with the people. You just go, they write their name and they give you to and they sign and all. So my point is, I'm giving you a very scratch thing. Once you do not have a format, what you need to look upon: parties, the background, terms and condition. Means whenever you have studied any agreement, the word is written whereas so and so, whereas so and so, whereas so and so. What is this? It means these are the certain terms and condition which outline this specifically what you are agreeing to that particular agreement. This can include, for example, for the products or services, payment terms, delivery, or any other relevant obligation related to the nature of the agreement that you are going to agree upon. Then next is you also have to agree to the scope. For example, what could be the scope of the work, description of your goods and services. So depending upon the nature of the transaction, you have to clearly define what is being provided, including the scope of the work, products or services. For example, I have a big plot, but I want to sell only a certain part of the plot to anyone. So I have to very clear that this side, this north facing, south facing, up to this square feet, I am ready to sell in this particular agreement to sell. So you have to be very clear about the description also. So whenever you read the agreements for the sale of the property also, you see that they give all four sides information, what is in south, what is in north, what is in west, east, west, everything is given there as an information. So to be very clear, at any time it is not leading to any dispute. Then payment terms, for example, will you partly pay at some time, will you be wholly paying? So all these terms has to be there, specifying the amount, currency, at what time you will be paying, including some late fees also, other charges also, if there is something, a charge on the property or the property is mortgaged or it is being kept as a security for certain thing. All these things need to be there in your agreement. It is not only of the property, it can be any good also. I'm just saying that these are the things which are required for looking into any agreement to make it valid or void, or to see whether it is a contract or not. Then delivery, or you can say performance, that when you want the performance. So for example, you have booked your plot, you have booked your flat, and now that building is being constructed, they give you a tentative that up to so and so will give you the possession. So this has to be very clear that up to what you have to wait, up when you will be getting the things. So all these things has to be clear. The next thing, what I'm telling you here is that it is not necessary that every agreement will have these clauses. It is on the parties what they are negotiating and the needs and the wants, what they want in that agreement. Then you have intellectual property. So you also specify the ownership or the usage rights of any intellectual property which is involved in your agreement, such as you do have certain types of intellectual properties, copyrights, trademarks, patents. So you have to be very specific about that thing. Then confidentiality clause is also very important. If there is some sensitive information that you do not want to share to the other parties, then you put that confidentiality clause. For example, when you take admission in any university, you do sign certain forms, then there is a confidentiality. Whatever will happen, it will be solved between so and so. It will not be disclosed to the other people, right? So confidentiality clause means that you want that information to be a protected information between the parties to the agreement, right? Termination clause is also there in some of the agreements, which defines the condition under which the contract can be terminated, right, by either of the parties. And if the contract is terminated, then what could be the consequences of that particular termination? For example, when you get a contractual job, then also you have to sign a certain contract, right? Then in that also you have certain terms and conditions that when up to what extent your job will be there, when it will be terminated, if it is terminated, whether you have to give notice or not, whether you have to refund something or not, right? So all these things you agree in your negotiations or while drafting your agreement. Then you also specify that what law will be governing. For example, one party is from Uttar Pradesh, other party is from Madhya Pradesh, right? So they will agree that which court will have the jurisdiction, because it's not always possible that every time this they will have a dispute. It's better to put this jurisdiction clause in the agreement, that if any dispute arises, the court of so and so will have the jurisdiction. So you also need to agree with the governing law. So an extension of this is the arbitration, whereby you parties can choose the seat, the place, their party. The more party autonomy is there in the arbitration. Then indemnification clause has to be there, whereby you need to define the responsibilities. What would be the responsibilities of each party in case there is a breach? And you also have to put it very specifically that this is indemnification. So what is indemnification and all that needs some more introduction or more understanding on that. You can study section 124 of the Indian Contract Act. Then the force majeure clause has to be there. For example, if something unforeseen happens, then what will be there? Who will fulfill what obligation? So you have to be very clear what rationale you can have, what force, what for like how much you can foresee. You try to put all the terms and condition so that at the time it is not creating any chaos between the parties for the smooth functioning of them. Because every time you can't say every next 2 day we'll sit and change the agreement things. So you draft keeping in view, because when you draft these things, it means you want a long term. It's not only for 2 days you are drafting it, right? The notices has to be there. You have to specify that how you will make the communication, whether you only make the written communication or it will be through email or it will be through post or whatever. So it makes the things more clear, because sometimes I may drop a mail, but the other person is not having access to mail. He may not see for 10 or 20 days, or it is in the spam folder, right? So all these things are also important. Then signatures, obviously without signature, you do not have any validity of your agreement. So then what I told you, while drafting, you have to look into these things, that there might be other things also. It's just few things that I told you. You have to be very clear, very cautious that yes, your agreement is very clear as to the different aspect, the four corners of your negotiation. That if such thing happens, what will happen? If you will not do, then what will happen? If I will breach, then what will happen? If both of us are not breaching, but it is the circumstances which are leading us to not fulfill the promises, then what will happen? Right? And if any agreement is not containing that clause, you may again put a like question to them and know that you please give me in written form. You can, then that will be an extension to your agreement, and that will also be a part of your main agreement. So that is what I wanted to discuss in a very brief and the review. So here are my contact details. If you want to contact anytime, you can email me, and this is my LinkedIn thing where we can get connected. So that's done from my side. Anyone, any issue or any doubt, we just have a 5 minutes and we'll quickly do that. I hope that you got something from it, the students particularly, because I started from the very scratch for them.
Ma'am, you just spoke about the confidentiality clause.
Right.
If at all there is a confidentiality clause, does it, if at all there is any investigation from the investigation agency, so do they have access to such contracts? Or
So
to take
the
the
contract is the accessibility of the contract. What I'm saying, if for example, there are property papers which are in anybody's home. As of now, it is my property. Nobody can just come to my home and just investigate my thing. But if the police who is coming with the warrant, it means that will always supersede. They may check my documents. in that thing, if there is certain clause and putting certain thing, that is in that thing, they have a power. But without warrant, you can't allow anyone to come to my place and see my things. And similarly happens in this thing. For example, if there is any dispute related to the contract, so it might be into the question, and I'll say there is no straight one answer to this. It may depend on situation to situation. If you see to the new laws, that are coming, so much of white power is given to the police that they can even seize your laptop at any time without any warrant. So you do have a lot of confidential information in your laptops, in your mobiles, in your electronic devices. So I think that's also a very gray area. Your questions are very, very good, Yogesh. Very good.
Obliged. Thanks.
Thanks. Okay, Akshay, can you be there?
Yes, ma'am.
Thank you, ma'am, for your enlightening session and sharing your knowledge and insights with us. Thank you to our wonderful audience for your active participation. To watch same seminars, please stay connected with Legal Innovation in future.
All right.
Thank
Thank you,
you.
everyone. So I'm just putting it off now.
Yes, ma'am. Thank you so much.
All right.